Hi, my name is Amber Widgery, and I'm a policy specialist with NCSL's Criminal Justice Program. Thanks for joining us today to learn more about recent changes in state criminal drug policy. This is an important and perennial issue for state legislatures, and recently, states have re-examined their approach to how certain drug crimes are penalized. This has included broad changes to drug crime sentencing, as well as a focus on some individual controlled substances. Many states have made changes to three areas of drug sentencing laws: modifying drug thresholds, expanding treatment and diversion alternatives, and altering mandatory penalty laws. To start, states have been making changes to what are broadly called drug thresholds. Drug thresholds are generally an amount of a controlled substance which determines the class of drug crime and the associated penalty. Recently, many states have amended penalties for drug crimes by changing the drug threshold. This has been accomplished by decreasing the penalty range, decreasing the class of offense for drug crimes, or changing the weight threshold for individual substances. The general intent behind these changes has been to differentiate possession offenses from more serious distribution or manufacturing crimes. Additionally, this has included distinguishing large-scale traffickers from offenders with substance use disorders. For example, Kentucky recently added weight thresholds to drug dealing offenses, increased penalties for the most serious offenses, and required probation for some drug possession crimes. More than one-third of states have amended drug penalty thresholds in the past 5 years, and recently at least 5 states have lowered some possession offenses from a felony to a misdemeanor. Just last year, Utah lowered the penalty for most first and second possession offenses to misdemeanors. In addition to modifying penalties for drug crimes, states have also started to focus more on diversion and treatment alternatives. States have statutorily created or authorized diversion options to address the treatment needs of defendants with substance use disorders in 26 states, and at least 43 states have statutorily provided for pretrial diversion alternatives to the criminal justice system more generally. Additionally, there are many local jurisdictions that have developed other diversion alternatives without any specific statutory authorization. An integral part of diversion programs has been connecting defendants with services and various treatment options. Medication-assisted treatment is just one method of treatment that has recently been addressed by lawmakers. West Virginia and other states have defined medication-assisted treatment generally as the use of medication to reduce withdrawal and other addiction symptoms in combination with drug screenings, evidence-based counseling, and behavioral therapy to provide a more holistic approach to the treatment of substance use disorders. States have legislatively authorized, required, or funded the use of medication-assisted treatment throughout the criminal justice system, including during pretrial release, as part of a drug treatment court program, in prisons and jails, and as part of reentry programs. Overall, states have increasingly considered it important to focus on the continuity of services as someone progresses through the criminal justice system. For example, Kentucky has legislatively supported treatment expansion by allocating 50% of the savings associated with the 2011 Justice Reinvestment, Sentencing, and Corrections reforms to support evidence-based and medically assisted substance abuse treatment in local jails and mental health centers. States have also been making changes to mandatory minimum penalties. These policies trump a state's primary sentencing system by requiring a minimum sentence length or a minimum amount of time or percent of a sentence to be served in prison. Mandatory minimum sentence policies may affect broad categories of crimes, including repeat offenders and many drug offenses. Many of these policies were adopted in the 1990s, and according to a report by the Pew Charitable Trusts, time served in prison grew by 36% between 1990 and 2009, which cumulatively contributed to an increase in state prison populations. More recently, though, states have eased mandatory minimum penalties for nonviolent and drug offenses. New laws have limited the circumstances under which courts must impose mandatory sentences, have narrowed categories of offenders subject to these penalties, or have given judges greater discretion to depart from mandatory penalties. For example, Maryland, North Dakota, and Oklahoma now allow judges to depart from most nonviolent drug mandatory penalties if they find that justice would not be served by imposing a mandatory penalty. In addition to focusing on drug crime policy in general, lawmakers have also turned their attention to specific substances, including heroin and prescription opioids, synthetic drugs, and marijuana. To address the recent surge in heroin and opioid-related deaths, States have taken other actions beyond treatment and sentencing changes. New policies directed at heroin and opioids specifically have included naloxone immunity laws, Good Samaritan immunity laws, and the scheduling of new substances such as acetal-fentanyl. Naloxone is a life-saving drug that acts almost immediately to reverse an opioid overdose. New Mexico was the first state in 2001 to broaden access to naloxone beyond the emergency room doors by allowing laypersons to administer it without any legal repercussions. Today, 47 states have enacted naloxone access laws, and in the last 5 years, states have worked in particular to broaden their laws concerning access to and distribution of naloxone. New Mexico was also the first state to enact a Good Samaritan or 911 immunity law in 2007. Generally, these laws provide immunity from criminal offenses and other legal repercussions as an inducement to encourage people to call for emergency medical help in the event of an overdose. Today, 36 states have Good Samaritan laws of some kind. States have also moved recently to schedule a new, very powerful opioid called acetal-fentanyl, which has recently been linked to a number of overdose deaths. This substance is related to prescription pain drugs fentanyl and morphine. However, it has not been approved for medical use. In addition to acetal-fentanyl, states have also been acting on other synthetic substances, including 2 major categories of designer drugs, called synthetic cannabinoids and synthetic cathinones. These substances are also known more generally as bath salts and synthetic marijuana. Since 2011, all 50 states have acted to regulate or ban these substances. Initially, state legislative action targeted specific versions of these drugs, with individual bans. However, minor changes to the chemical composition of these substances can create new, but very similar drugs that were not previously covered by law. In response, legislation in subsequent years has been more general in nature, targeting entire classes of substances or using broad language to describe the prohibited drugs. Marijuana is another substance that has been addressed by state legislatures. 20 states and the District of Columbia have decriminalized small amounts of marijuana. This generally means that certain small, personal consumption amounts are a civil or local infraction or not a state crime, or are a lowest level misdemeanor with no possibility of jail time. In addition, a handful of states have voted to legalize adult-use marijuana products through the initiative process. Drug crime policy is an issue that legislatures will continue to address in the future. For more information about drug crime policy, please visit our website at the link listed on the screen. Thanks for listening.